that if you did not do what I asked you, then your bond would be raised and you would have to go back to jail, right?
No.
Yes, that's exactly what I say, because I say, you've heard me say it probably 8 times already this morning. So at this time, Mr. Brown, because you did not do what I asked you to do, or what I ordered you to do, I'm going to raise your bond.
Challenge subject matter jurisdiction.
That's overruled. Listen, Mr. Brown, I'm raising your bond to $100,000 in each of your cases for not following the court order. Go back with the bailiff. Go back with the bailiff. Go back with the bailiff. You're going to make it worse if you don't.
Yeah, respectfully, this is not a fair trial.
You don't get to say respectfully and then be disrespectful. Go back with the bailiff.
She started.
Don't make me lay hands on you.
Why would you lay hands on me?
Because you're not doing what I'm telling you. Now go.
Mr. Brown, you need to go back with the bailiff. Right now, I've raised your bonds. You have to go with the
I am
bailiff.
not a threat to any officer.
You through him, Judge?
Yes, I'm through.
I am not a threat to any officer.
Let's go.
Why are hands on me?
Yeah.
Why are
I
hands?
told you I was gonna put hands on you.
Why are hands being put on? Y'all see this on the camera?
Good morning. You're Armand Gregory. And Mr. Gregory, were you able to get someone hired?
No, ma'am. Yes.
Who'd you talk to?
We had 3 calls that are prices for one.
Speak up, please.
I got prices for one, and Mr. Walker, I talked to Mr. Walker. Clayton, Prince out, Mr. Gaines,
Who?
McLean.
Okay. And so, where are you on being able to get someone hired?
All their price was too high. Mr. Walker just told me it was too expensive. So,
Are you working?
um,
Why not?
I was working out of town, so I couldn't go out of town, then come back.
Gotcha. So thank you for talking to those lawyers, Mr. Gregory. I'm gonna have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Make sure you fill it out accurately and completely. You're gonna swear under oath that it's all true, and then I'll take a look at it, okay? Step in front of the clerk on the end. She'll give you that paperwork. Tyrania Johnson. Good morning.
Thank you.
Is it Tyrania?
Tyrell.
I say it wrong every time. I'm sorry. Ms. Johnson, were you able to get a lawyer hired?
No, ma'am. I have a reason. Well, I did talk to 3 of them. I talked to Mr. Robos,
Yeah.
Mr. Joseph, and Mr. Wright. But in the process of me talking to them, I had courts, and they told me it was going to combine it with this court. And she told me that I was going to get an attorney appointed to me.
What other court do you have?
I had it. It was my misdemeanor. They told me they didn't want to interfere with this because it's dealing with it. So she told me they was going to combine it. But when I messaged her,
Who is that? Who told you
it's
that?
British.
Okay. So typically what that means is usually they'll handle your felony first. But you still, it doesn't get combined in one court. So I don't want you to misunderstand. So if you have a court date down there, you still have to go. So sometimes they'll do things with your cases that are kind of similar, but it's definitely 2 different things, 2 different courts. Okay.
Yes.
So, are you working? Are you able to hire someone?
Yes, ma'am. Like that.
You think you'll be able to hire someone?
Yes, ma'am.
Okay. So if I give you one more reset, can you get that taken care of?
Yes, ma'am.
All right. So make sure when you go, let them know that you do have both of the cases, one in felony court and one in misdemeanor court.
Okay.
But this one is definitely the one, obviously, that's more serious to make sure you try to get someone hired.
Okay.
If for some reason you can't, talk to at least 3 others, bring me those names, and then we'll discuss your options. Okay. All right. Step in front of the clerk. Cedric Martin Harris. Good morning.
Good morning.
You're Cedric Martin Harris?
Yes, ma'am.
And Mr. Harris, this is your initial appearance. Just a second. In cause number 26, DCCR 0421. You're charged with the state jail felony offense of burglary of a building, and that's from February 4th of 2026. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? So what I'm going to do, Mr. Martin Harris, is reset your case for about 30 days to give you some time just to see if you can hire someone. If you do get someone hired, bring the reset notice that you get today to that lawyer and they'll tell you what to do.
Yes.
If you're not able to hire a lawyer, I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand? Step in front of the clerk right here. She'll give you a reset. Jerikia Holland. Good morning. How do you say your first name? Jerikia, and you're Jerikia Holland?
Yes, ma'am.
And Ms. Holland, this is your initial appearance in cause number 26 DCCR 0386. You're charged with the second-degree felony of aggravated assault with a deadly weapon, and that's from February 5th of 2026. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No.
So what I'm going to do, Ms. Holland, is reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do.
Yes.
If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers you talk to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand?
Yes.
All right, step in front of the clerk. She'll give you your reset notice.
Mr. Yeah.
Keyshawn Spriggs. Good morning. You're Keyshawn Spriggs.
Yes,
You
ma'am.
look very nice this morning, Mr. Spriggs.
Thank
Mr. Spriggs, this is your initial appearance and cause number 26 DCCR 0665. You're charged with indecency with a child, and that's from March 4th of 2026. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Yes, ma'am. I have a constellation at on the 17th with Mr. Marcus Wilkerson.
Okay,
Yes.
so what I'll do, Mr. Spriggs, is reset your case for about 30 days to give you some time to see if you can get him or someone else hired. If you do get Mr. Wilkerson hired, make sure you bring the reset notice that you get today to him, and he'll tell you what to do.
Yes, ma'am.
If you're unable to hire him or someone else, make sure you visit with at least 3 others. You'll see that they all charge different amounts, different payment plans. Bring me the names of the lawyers you've talked to so I know you're trying, and then we'll discuss your options.
Yes, ma'am.
If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand?
Yes, ma'am.
All right, step right here in front of the clerk. She'll give you a reset.
Would he just make that?
Joshua Tyree. Good morning. You're Joshua Tyree.
Yes.
And Mr. Tyree, this is your initial appearance. You have 3 cases. Cause number 26, DCCR 0078. You're charged with unlawful possession of a firearm by felon, and that is from September 21st of 2025. And then in cause number 26, DCCR 0079, you're charged with the 3rd-degree felony of tampering or fabricating physical evidence with intent to impair, also from that same date. And then in cause number 26, DCCR 0080. Just a second. Get that. You're charged with the 2nd-degree felony offense of possession of a controlled substance, also from September 21st of 2025. Since you've made bond in your cases, have you had an opportunity to try to hire a lawyer?
No.
So your indictments also allege 3 prior felony offenses, which mean all of these, you will be considered a habitual offender. which means if you're found guilty, your punishment range is a minimum of 25 years up to 99 years or life in prison. You understand?
Yes, ma'am.
So it's very important that you try to get someone hired before that next court date. I want to reset your case for about 30 days to give you some time to try to hire someone. If you get somebody hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what you need to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you will go back to jail. Do you understand?
Yes.
Also, was it a requirement that you were told that you were to wear a drug patch?
Yes.
And you have that on? All right, so it's very important that that drug patch is obviously negative. I get those results. So every 2 weeks, you have to go get it changed. Make sure you get it changed on time and that it's negative. If there's a positive result, your bond's going to get raised and there'll be a warrant. You'll go back to jail, okay?
Yes, ma'am.
All right, step in front of the clerk. Darian Broussard?
There's that from the community officer.
I've got good morning, you're Darian Broussard. Give me just a second, Mr. Broussard. Let me read this real quick. So when you were here last time, I had you go get a drug patch. Well, I know you did, but then you didn't go get it changed when you were supposed to.
I had fired.
What?
And when I went to jail, I got fired from my job. So, man.
Have a seat in the jury box. Let's get you tested this morning. Nasir Brown.
My glasses.
Are you Nasir Brown? Either AB or Hinton here this evening. They're usually my backup.
And just record on y'all know that's not mine, that's Charlie's.
Just wait a minute till we get some back in here.
So they come.
And this company.
Huh? Yeah. Hey, I just looked up. I said, "Where's my backup?" Yeah.
They're dangerous. For the first, yeah.
That station.
But it can get furnace.
Right.
This one. Amon Colbert.
Yeah. Yours is gonna be something.
Okay.
But I'll be smart, yeah.
You're Amon Colbert.
Yes, ma'am.
Mr. Colbert, don't wear sweatpants to court.
Oh, I'm sorry. I'm sorry.
It's felony court. You need to dress appropriately. All right. So were you able to get someone hired?
I was told I was supposed to go with Mr. Rennick, but Mr. Rennick was up on me, so I talked to Mr. Bailey, and he has a girl named Haley out there. Haley, pay her, and she told me she wasn't gonna be able to take the payment because the court date was so close.
Right.
So she told me to make a payment this week to start up a payment plan
Okay.
and reset if I get one,
Sure.
and then she'll take it from there.
And it's Haley.
I don't know her last name. I'll have to call Mr. Bailey.
Simmons?
I think
Does
so.
that sound right?
The Jensen Bailey, something like that.
Okay.
It's all right.
If you'll just make a notation, Kim, on there that he's going to hire, I think it's Haley Simmons, just maybe a question mark with Jensen Bailey's name beside it also. You need to get someone hired before that next court date. Okay? Step in front of the clerk. Hi. No, I'm glad you did because I couldn't, and I knew it. I just couldn't, and for the longest time I had it on a sticky note because I had a, yeah, I don't know another one. Wesley Mack. Yes. Uh-huh. Happy Monday. Good morning.
Good morning.
You're Wesley Mack. And Mr. Mack, this is your initial appearance in cause number 26 DCCR 0776. You're charged with the third-degree felony offense of tampering or fabricating with physical evidence, and that's from March 15th of 2026. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? So what I'm going to do, Mr. Mack, is reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts of different payment plans. Bring me those names of the lawyers you've talked to when you come back, so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand?
Yes.
You'll step in front of the clerk right here. She'll give you that reset notice. Sierra Mitchell. Good morning, ma'am. He's good. Okay. You're Sierra Mitchell? And Ms. Mitchell, this is your initial appearance in cause number 26 DCCR 0779. You're charged with the state jail felony offense of abandoning or endangering a child with intent to return. That's from March 31st of 2026. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? All right. So what I'm going to do, Ms. Mitchell, is reset your case for about 30 days, give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do.
Okay.
If you're unable to hire someone before the next court date, I'm ordering you to visit with at least 3 lawyers. They all charge different amounts of different payment plans. Bring me back the names of those that you've talked to, so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand?
Yes, ma'am.
You'll step in front of the clerk right here. She'll give you your reset notice.
Oh, chucklehead today.
It's Nasir Brown.
You gave me something else, but
No, it's, yeah. He's trying to be a sovereign
Sovereign
citizen, I
citizen.
think.
He's
He's not.
You did that last time.
Yeah. I remember.
I didn't do it. You shouldn't good.
Rory Parker. Good morning, sir. You're Rory Parker.
Yes, ma'am. Good morning.
And Mr. Parker, next time, please do not wear sweatpants to court, okay?
Yes.
Mr. Parker, this is your initial appearance in cause number 26 DCCR 0782. You're charged with driving while intoxicated, 3rd or more, and that's from February 25th of 2026. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? All right, so what I'm going to do, Mr. Parker, is reset your case for about 30 days to give you some time to try to hire someone. Thing. Are you, do you have that ignition interlock device on your vehicle?
Yeah.
Okay. So, I'm going to, if you get a lawyer hired, I'm gonna give you about 30 days. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do.
Okay.
If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. You need to bring me back the names of the lawyers that you've talked to, so I know that you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order. You would go back to jail. Do you understand?
Yes.
If I test you this morning, Mr. Parker, you gonna have anything in your system?
No.
Let's double check that. Have a seat in the jury box, please.
Second check.
Lamudra Walker? I know I said that wrong. I'm sorry. Good morning, ma'am. How do you say your first name?
Lamadra.
Lamadra, and you're Lamadra Walker?
Yes.
And Ms. Walker, this is your initial appearance in cause number 24 DCCR 0846. You're charged with forgery of a governmental instruments, a state jail felony from February 14th of 2023. Since you've made bond, have you had an opportunity to try to hire a lawyer?
I got a court-appointed lawyer.
You did. So what happens is everybody that gets arrested on a felony gets an automatic court-appointed attorney.
Okay.
But once you bond out, I expect you to at least try to hire your own lawyers. So I'm going to reset your case about 30 days to give you some time to do that. If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, different payment plans. Bring me the names of the lawyers you talk to, so I know you're trying, and then we'll discuss your options. If you don't do that, then you run the risk of me raising your bond for not following that court order, and you would go back to jail. You understand?
Yes.
All right, step in front of the clerk. She'll give you a reset notice. Del Mario Whitfield. It's today. Good morning, sir.
Morning.
Did I say yours right?
Yes, you actually did.
Okay, Del Mario Whitfield. And Mr. Whitfield, you look nice today also. Figure I fuss at people for not looking nice, so I'm gonna let those know that do. Mr. Whitfield, this is your initial appearance in clause number 26 DCCR 0672. You're charged with the state jail felony offense of driving while intoxicated with a child under 15. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? So you've heard Mr. Whitfield, I'm going to reset your case about 30 days, give you some time to get someone hired. If you do get someone hired before that next court date, just bring the reset notice to that lawyer. They'll tell you what to do. If you're unable to, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts of different payment plans. Bring me back those names of the lawyers you've talked to, so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond, and you would go back to jail. Do you understand? All right, if you step in front of the clerk, she'll give you a reset notice. So this last one needs a thumbprint still. You see that on your, I'm sorry. That's okay. I just see the note on there. Wesley Smith. Wesley Smith. Well, may not matter.
Get over that.
That was a big bucket to have only one no show. Huh? Well, no, that was pretty good for initials, though. That's what I meant. Yeah.
No response, Shawna?
Bond will be forfeited for non-appearance and reset at 100,000. Mr. Broussard, you can come back up, sir. All right, Mr. Broussard, you tested negative, which is great. It's very important that you do the best you can to get that changed every 2 weeks, okay?
Yeah, for that, keep,
Okay.
the money, so.
Good. Okay, sounds good. Do the best you can. And then you're on probation down in misdemeanor court, so you can expect to be tested through them as well. So we'll keep up with it that way. So, Mr. Were you able to get a lawyer?
I talked to several of them.
To 7?
And they literally, I got it all down in that hotel.
Okay. Thank you for doing that. And
4,000, 3,000, 4,500.
Okay.
So very bank because he'll take payment plan $1,000 down.
so do you think you'll be able to get him hired if I do one more reset?
Yes, ma'am.
Okay, I'm gonna reset your case one more time, see if you can get Mr. Burbank hired. If so, just bring the reset to him. If not, see if you can talk to some others, and if you still can't, we'll discuss your options at that next court date, okay? Just step in front of the clerk, she'll give you a reset notice, and if you'll just write Burbank on this for me.
Yes.
Let's see, Mr. Comerford, are you ready on Ryan Rainey?
Yes, Your Honor.
Good morning. Morning.
You file something, I haven't had a chance, it's just a special measures we put in.
Good morning, sir. You're Ryan Rainey.
Yes.
And this is cause number 25 DCCR 1246. Mr. Remy is charged with driving while intoxicated with a child passenger. It looks like just recently there was a motion to suppress filed. Is that something, do you believe, Mr. Comerford, that would be dispositive of the outcome of the case if I hear it prior to trial?
Yes, Your Honor.
Okay, so let's do this. I'll set it for a hearing on that in the next 30 days or so. We'll find a time when we have a couple hours at the most. I wouldn't think it would take more than an hour or two.
Okay.
I haven't looked at it, Judge, but I
Okay. And then we'll I'll go ahead and take care of that. That way you guys know how to proceed depending on the outcome of that.
I have a jury trial July 8th, so I just want to make that availability. We can just anytime in July would be fine, just not last week.
Okay.
That,
No, it won't be on a regular date. I'll have to find a date for us to have some time for the hearing. Just make a notation for me and we'll take a look at it. Make that, if you'll put not July week. Okay. All
Thank you.
right. Stay in touch with Mr. Comerford. He'll let you know when you need to be back and ready for that hearing. Okay. All right.
Thank you,
Thank you. Mr. Paget, you have Michael Harrison Jr.
Yes, Your Honor. Yes,
Good morning, sir. Are you Michael Harrison Jr.?
Yes, ma'am.
This is 25 DCCR 1859. Mr. Harrison is charged with driving while intoxicated, third or more. And what is the announcement?
Your Honor, we reviewed the evidence, received an offer, and if you can give us a plea date, needs to arrange some time on the weekends for.
All right,
Yeah.
any issues?
No, you're.
You've got the ignition interlock device. Make sure you keep that, take care of that, and we'll just do a normal reset for a plea on the
Yes,
plea
Your Honor.
docket. We'll take care of it on that day. All right.
Thank you, Your Honor.
Thank
Have
you.
your excuse.
Yes, sir.
Thank you.
See, Judge Walker, you've got Daniel Ward's sentencing. That one's done. That's for you. Okay. I need that. Thank you. Good morning.
How are you, ma'am?
Good. How are you?
Monday morning, hey, something. How are you? Good.
Good morning, sir. Are you Daniel Ward?
Yes, ma'am.
And Mr. Ward was previously in court and cause number 25 DCCR 1375, entered a plea of guilty to driving while intoxicated, third or more. I've received that pre-sentence report. If you both had an opportunity to review that report.
Yes, ma'am.
Noodles.
Yes, Your Honor.
Any additions or corrections?
The only thing I would add to it is they've determined to be a moderate to severe risk. So the issue that I have with that is that the bulk of his criminal conduct is 21 years ago
Right.
and 24 years ago. The last DWI that he had was 13 years ago. And what I would ask Judge is simply, I don't take away from what his history shows, but being that it's been 13 years before he's had any issues with drinking whatsoever. If the court is inclined to move forward with the JCDI program and various programs, I would simply ask maybe the court consider ordering it, but holding it in abeyance. And if he has any issue, any hiccup whatsoever while he's on probation, then about that. But 13 years is a pretty good amount of time.
Well, I agree with you on that. The issue that I've got really is from that substance abuse assessment, which doesn't really have anything to do with the length of time or what the history is. It's just what's going on now and what their determination was. And their determination was severe alcohol use disorder as well as severe sedative disorder. And I think to make sure that he is successful, I am inclined to order what they have requested so that we don't have any issues.
If I may, to say, I think I've always said the best indicator of future behavior is when you've done 13 years is an incredibly long time to go for anybody. So at the end of the day,
Well, how long have you gone?
I've gone for 61 years, Judge.
Right.
But at the end of the day, but for the grace of God goes I. And
Same here.
so anyway, whatever the court's wisdom, the only other
Thank you.
thing
I appreciate that.
he does have to do 10 days as a condition.
Yes.
He's full-time employed.
Okay.
We have asked that he do it on weekends.
Yes, no problem with that.
No issue.
So any issue with starting this weekend? It would be from Friday. You'll go in Friday at 6. They'll let you out on Sunday and you'll do that.
I mean, if you can do it, great. If not, she just needs to know a date.
Can I have like a 2-week notice, like not this weekend, but the following?
Are you working this weekend?
Yes, ma'am.
Okay, so here's what I'll do, Mr. Ward. I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of driving while intoxicated, third or more. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that. Place you on probation for 5 years. You're ordered to follow all of the rules and conditions of probation. That includes paying a $500 fine. You will be ordered to serve the 10 days upfront time, and I will do some dates on that in just a second. Also, I am going to order that you enter and successfully complete that JCDI program. I understand and respect what your attorney's asking for, but just based on the information that I have, I think it's important that you have those tools up front so that this doesn't ever happen again in 1 year or however many years. All right. So you will be ordered to complete that program. If you do everything that you're supposed to when you're on this probation, this is a great opportunity because you'll be able to serve that sentence while you're out on probation. The other side of that is if you violate any condition of probation, you can be brought back into court and you could be facing that 10-year sentence in prison that you've already agreed to. Do you understand? So we're going to start your weekends on June 19th. So that's a week from this Friday, and you'll go in Friday at 6 o'clock to the Jefferson County Jail. It's important that you're on time. If you're late, you can be considered a no-show. Obviously, if you don't show, it's a violation of your probation. It's very important that you don't. Some people think, and I know this isn't going to be you, that if they show up intoxicated, they're going to sleep it off for the weekend. Please don't do that. That's obviously a violation of your probation. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with your attorney, okay? You need to have a seat here in the courtroom. Probation is going to call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, sir. Thank you. Oh, okay. Okay, I hope you'll show that you'll go grab it real quick. You can come up, Mr. Parker. All right, Mr. Parker, you tested negative, which is great, obviously. You're going to get over here and get your reset notice. Make sure you try to get someone hired to follow all of those rules, okay?
Yes, ma'am.
Thank you. He's got that one. Mr. Rojas, you have Fernando Garcia.
Good morning. I'll have to translate for Mr. Garcia.
Thank you, Mr. Rojas. Oh, wait, I don't see paperwork yet.
Oh.
Just want to give the credit that I didn't bring them.
That's right. It's on there.
You should.
Thank you. And for the record, Mr. Rojas, you're going to translate for Mr. Garcia, correct?
No.
Good morning, sir. Are you Fernando Garcia?
Yes.
And Mr. Will your client waive the formal reading of the indictment?
Hey, William.
Mr. Garcia, in cause number 25, DCCR 1144, you're charged with the state has elected to proceed on the lesser included offense of evading arrest or detention, a class A misdemeanor. And that's from July 12th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? So you can't change your mind later if I follow this agreement. You understand?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
And it looks like the agreement that you've reached is for a 1-year deferred probation, $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Garcia is not competent?
No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made and defer all proceedings and place you on probation for 1 year. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. If you do that, this is a great opportunity because you don't have a conviction on your record. And at the end of the probation period, if you're successful, the case will actually be dismissed. You'll never have the conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to the Jefferson County Jail for up to 1 year. Do you understand?
Yes.
I'm handing you the trial court certification that shows that this was an agreement that I followed. And so you have waived your right to appeal. If you'll just have a seat here in the courtroom, probation will call you up when she's ready to go over your paperwork. And Mr. Rojas, if you'll help with that.
I will.
Thank you.
Thank you, Judge.
We didn't have them. We didn't know what was happening. Where did they are?
Mr. Macon,
Yes.
I don't see you on my docket.
I just realized I'm in the wrong part.
Good morning. Nice to see you.
I'm just nervous.
That's okay. Mr. Parker, you have Christopher Rhodes.
He's here, Judge. I just found I have.
Good morning, sir. You're Christopher Rhodes?
Yes, ma'am.
This is 26 DCCR 0209, and Mr. Rhodes is charged with driving while intoxicated with a child passenger. What is the announcement?
We have an agreement, but they need to re-indict him. And so I think Mafino said a couple weeks or.
Judge, he provided the mitigation documentation this morning to allow me to re-indict this to an endangering from a UWI child passenger
Okay.
so that he may receive deferred. I could have it indicted on Wednesday and be ready to plead sometime in the next 2 weeks.
All right, we'll just do about a 2-week reset. And Mr. Rhodes, make sure you stay in touch with Mr. Parker. He'll let you know when that next court date is, and we'll take care of it. We'll put it on a plea docket on that next court date. All right, free to go.
Thank you.
You get, that'll be a plea docket, Anna. Thank you, ma'am. Virginia Williams. Good morning.
Good morning.
So this is Miss Malfino.
Ashley.
Miss Malfino on Virginia Williams. Good morning, ma'am. You're Virginia Williams. And this is 26 DCCR 0218. And what is the announcement?
Your Honor, she's informed me has documentation that she's supposed to provide today. Which I think will resolve the case if it says what she says it says, but I have not seen it. She told me she can have it today, and I'm asking for like a 2-week reset.
So why haven't you gotten that to Mr. Parker already?
Because the people didn't meet me to sign the affidavits at the notary, but they said that they'll meet me today.
Okay, so I'm gonna do about 2-week reset.
Yes, ma'am.
Well, let's do this. I'll just do a normal reset, okay? Get that as quickly as you can to
Yes,
Mr.
ma'am.
Parker because he needs to get it to Ms. Malfino so she can take a look at it, and then it may or may not make a difference in your case, but she'll take a look at it once that's done. If for some reason that doesn't happen, then when we come back, we'll need to do something with the case, okay?
And Judge, if I may, just to reiterate what the court said, based on her prior criminal history, it's not likely that that affidavit is going to suffice.
Okay.
But I'm happy to take a look at it, but I will make 2 alternative offers.
Okay, thank you. So
Thank
make
you.
sure you visit with Mr. Parker, before that next court date as well.
Okay, thank
Okay,
you.
thank you.
They said I have another one, but I don't have the bond. I
I
don't.
don't have anything else.
Okay.
No, the heroes.
So you stay in contact with your.
Mr. Galmore, you've got Austin Talbot, sentencing.
Yes, Your Honor.
Sentencing. Austin Talbot. Good morning.
Morning, Judge. How are you?
How about you?
All right, fantastic.
I do. I have.
Right, sir, you're Austin Talbot. You want to switch with Ms. Malfino, please? Thank you. And Mr. Talbot was previously in court, entered pleas of true in a motion to revoke his probation to counts 1 through 6, is on probation for aggravated assault. It was a 5-year deferred probation that he received in March of 21. And then a 5-year term for burglary of a building, as well as a misdemeanor driving while intoxicated. And I've received the updated pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor.
I have, Judge.
Okay, so the burglary of the building and the DWI were both, they were actually first. He was on probation for that when he was placed on probation for this case. Those are
Expired.
expired. So we're currently just on the aggravated assault, which technically expired, but the motion kept it open, so we can do whatever we want on that one, correct?
Yes.
And you both had an opportunity to review that report.
We have, Your Honor.
Yes.
Any additions or corrections?
No corrections.
Ms. Muffino?
No, Judge, other than the fact that, but I handled all of these cases before this court. The burglary of the building involved a little league, down in Lake County, if you'll recall. Obviously, it was quite some time ago, but we were all here. And I do have notes reflecting the, level of fear of the original complainant. I have not had the opportunity to study in depth the original PSI, but I know the court has it as well. I just ask you to take those things into consideration in addition to the fact that with those prior the DWI here and other history here, he has subsequently fled true to a new offense. I know that's more argument than addition, but that's all I have, Judge. And unless the probation department, and this gentleman is here for Ms. Broussard. I thought it was going to be Ms. Broussard, but I'm happy for him to add anything.
And what's your name for the record, sir?
Mr. Broussard, Dallin Broussard.
That's what I thought.
Yes.
Okay.
I was about to say, I thought that was, yes, nice to see you, sir. Do you have anything to add to the updated report?
Nothing to add. No, ma'am.
Okay. And what is the status of that?
It's pending. He has a court-appointed attorney in that county. It's up north. The only discussions they've had as of right now is that it looks like they're going to offer him probation, but nothing has occurred yet. He's got another court date.
July 21st.
July 21st.
Or 24th.
We believe the case will be resolved on that date. If the outcome of that date makes a difference to the court, we'd be more happy to reset this until just after that next court date. But we do believe that the outcome is going to be probation there.
I mean, it's still a misdemeanor, but it's the second. So it's a class A, I guess.
That's correct.
All right, go ahead, Mr.
I would say, Your Honor, since we were here last, the plan was for Mr. Talbot to be able to continue to go to work where he's working. He moved in the kind of this process and the court allowed him to transfer and work there. But since we were here last, his child or his son's been in the hospital pretty much the whole time. We do have a letter here. He came from the hospital yesterday. His son's in the Texas Children's Hospital. He has not been able to work since he's been here. He has not made a single payment since we were in court last. He has not really been able to work either since we were here last. So unfortunately, he's just dealing with his son's medical condition, and that's all I've been able to do as far as financials is concerned. Of course, the only thing he pled true to was basically the financials and this new offense, which occurred out of the county. So there's a few technicals along with that.
So what's your?
Judge, what we're asking the court to do is consider either continuing his probation. I believe he's already reached the expiration date, but for this, he would have successfully concluded his probation. But because of this, we would ask the court to extend his probation, which has there's a lot of time left that the court could extend, or just reset and see what the outcome of the DWI is going to be. But I do believe it's probably going to be 2 years probation with the interlock requirement.
Ms. Muffino?
Judge, I will defer to the discretion of court because he has not had any other violent type of issues and because he has that issue with his child, which of course I know everyone's sympathetic to, whatever you think.
What was the date of the offense of this DWI second? When did that happen?
I don't remember. It's like a year. Almost like that.
May of 25. All right, so here's what I'm going to do, Mr. Talbot. I'm going to find that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Well, let me ask this. Do you have an interlock device on your vehicle now?
I'm not driving. I have a handheld.
You do?
Yes, ma'am.
Okay. And you've agreed not to drive?
Yes, ma'am.
All right. So what I'm going to do is find that you entered your pleas for true to counts 1 through 6 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation. I'm not going to do that. I'm going to extend your probation by 2 years. I am going to order that as a condition of your probation, you enter and successfully complete the JCDI program. I understand that without driving and with having issues with your son, that could be difficult, but it's going to be required regardless of what else is going on.
Is that his probation was transferred to Angelina County? Is that something that Angelina County will do?
If they have, most counties have some type of program that is similar. And so whatever similar program they have, I would be willing to order that I'll have the probation officer look into that, but it has to be more than just, testing and stuff like that. I want an actual program. And if they don't have one, then get back with me. We're gonna have to figure something else out. This is the last opportunity you're going to be given here. You've been given a whole lot of opportunities. It will not matter what else is going on in your life. If you are unsuccessful after today, you will be looking at prison, and it's between 2 years and up to 20 years. So you've got to think of not just short term with what's going on with you and your family, but long term to be able to be around as well. Do you understand?
Yes, Your Honor.
All right, so there was no agreement on this, and so you do have some rights to appeal. I can't imagine why you would want to, but I'm going to hand you that, Mr. Galmore, if you guys will sign off on this real quick and give him that bottom copy, and then just talk to probation. Today, Mr. Broussard will let you know what you need to do so that he can look into whatever program they have up there in that county. What is that, Diboll County, or is Diboll Angelina County? Okay, we'll check into that. Thank you, sir. Thank you for being here. Good luck to you.
Thank you, Judge.
Thank you. Ma'am. And you can, if you'll go stop and talk to probation right over there.
We start seeing all the probation officers, kids, be probation officers within here.
Yeah, we have.
It's true.
Let's see. Mr. Gertz, you've got Remington Boykin.
Judge, can we hold on that?
Yes. And then Edgar Castillo. Edgar Castillo.
He's present, Judge.
Very different.
What? Yes, okay.
Good morning, sir. You're Edgar Castillo.
Yes, ma'am.
And this is 25 DCCR 1052. Mr. Castillo is charged with evading arrest or detention with the use of a vehicle. And what is the announcement?
We have a deal worked out. We're gonna need to have a little time to sign everything up.
I'll hold it. You're going to do that today? Yeah.
I believe so.
Okay. Just have a seat, sir. Blaine Dunnigan. Hold that.
Please, Judge.
And then Toy Frazier.
Boy. Yes, we can reset that with permission from the.
Good morning, sir. You're Toy Frazier.
Yes, ma'am.
And this is 25 DCCR 1494. Mr. Frazier is charged with giving a false name or information or forging a vehicle registration. And what is the announcement?
Judge, we're asking for a little time on that. If we could have a normal recess and Ms. Malfino and I can discuss.
Okay, Judge, this case actually was the tax assessor director.
Yeah, I'm just looking. It looks like you were signed on in October of last year. So this will be the final reset. So make sure y'all get together, visit Mr. Frazier. Make sure you stay in touch with Mr. Gertz. Once he gets any information, we'll get an announcement at the next court date. Okay, thank you. You're free to go. Make that notation, please. Felicia Freddie.
All right, Judge, I'm gonna this morning. We've got getting ready for this other trial this afternoon.
Good morning. You're Felicia Freddie. And Miss Freddie, this is an MTRP and cause number 24 DCCR 1390. What is the announcement?
Judge, if we could have a few minutes, I think I'll be able to get this resolved today.
Okay, sure. I'll hold
It's
it.
an MTRP, Judge. So.
Thank you. Just have a seat, ma'am. Okay. And then you've got Miguel Martinez, Mr. Gertz.
Yes, Judge. He's present.
Right, so you're Miguel Martinez. This is 25 DCCR 0584. Mr. Martinez charged with aggravated sexual assault of a child. And what is the announcement?
Judge, the state made us an offer and we have made a counter offer in the case. And I think the state needs to get input from the family, is my understanding. And so they're not saying no, they're just saying, let us check. So I don't know if you want to do 2 weeks or 3 weeks.
I'm going to do 2 weeks. It'll be the final reset. It looks like this has been about a year.
There is a possibility that I'll be in trial in Lufkin and federal court on that day, but we will let you know.
Just let us know and we can push it a week or two if we have to. Make sure you stay in touch with Mr. Gertz so that once he visits with Ms. French, you guys know, because this will be the last reset for an announcement.
Yes, Your Honor.
Snowballs popping.
Yeah, and Dan Church.
Oh, yeah. And
It's a bond hearing, right? Dan Church. That's with Miss Malfino. Good morning, sir. You're Dan Church.
Oh, yes, ma'am.
And this is 26 DCCR 0612. Mr. Church is charged with deadly conduct, discharging a firearm. And the state has filed a motion asking that well, I'm looking at the state's motion. The motion it says aggravated assault, but the charge is deadly conduct. That just
I'm sorry, Judge, that's my error. I was
Okay.
trying to file it rather quickly after receiving the affidavit from the complainant, and I'll fill the court in on that as to why I don't have a witness present.
looks like the current bond is set at $20,000. The state has asked to raise that bond. Ms. Malfino?
Excuse me, Judge, and I apologize about that error. Obviously,
That's fine.
the court would see the probable cause affidavit. It's very similar to an aggravated assault, discharging a weapon somewhat in the direction of the complainant. In this case, I have had multiple conversations with Jeremy Shelton, the complainant. He is the across the street neighbor of Mr. Church. He is a very nice young man. He was very forthright, came in and presented me or had an affidavit authored by himself with one of my investigators in lieu of coming to docket today. He, as the court can probably surmise, is of the mind that he doesn't want to aggravate the situation. Nope, not intending to use that same word, but I will tender that as State's Exhibit number 1, just for purposes of this hearing. And I have Mr. Gertz, it's his affidavit just expressing concern about the nature of this offense and the fact that they reside across the street from one another, that he has a very young son and a wife who were also present at the time of this offense. And he has concern that Mr. Church may be keeping weapons at his sister's house down the street. I have worked very closely with my investigator, Mr. Bays, and he is familiar with Mr. Church as well as Port Arthur Police Department is. And we've asked that some things be implemented in the interim time period to hopefully assure the safety of all the parties, including Mr. Church. I just wanted to bring this matter to the court's attention with that motion. It's not necessarily intended to increase as much as it is to modify with the admonishment regarding weapons, et cetera, because obviously it's difficult to remove these two individuals from one another approximately because of where they both reside.
Any objection to me reviewing that?
Well, Judge, the rules of evidence don't apply in a bond hearing, so I would love to have some great evidence, but I don't have a good one.
And I'll state the ones admitted for purposes of this hearing. Give me just a second, please. Mr. Gertz?
Judge, I'm happy to discuss bond conditions. $20,000 is more than sufficient, though, in terms of the amount for for this allegation as it stands right now, or as it's indicted right now, I would, Mr. Church wouldn't, I think, object to the normal conditions of not having any contact with the complainant, not possessing any weapons.
Those are already conditions.
Right. I'm not sure what else, what else the court could impose, because of the proximity of their homes without infringing on his constitutional property rights of his own. But I think the fact that he's, hired counsel, has shown up to court, he's taken this seriously. He's not been threatening the complainant or anything of that nature. I understand the complainant may have concerns, but those are the complainant's concerns. They're not being triggered by anything, no pun intended, by anything that Mr. Church has done since his arrest or his indictment. And so, and he's not violated any of his bond conditions that
No, I think
that I'm aware of,
concern
or that-
is if they feel like he is watching, could be, just uncomfortable. There's an allegation that he's sitting in his car watching family, obviously based on the nature of the offense and the allegations and the probable cause. That would give me some concern too, if I lived across the street and that had actually happened. So,
but I don't think, I just don't think raising his bond and just charging him more penalty is the proper remedy for that. So I'm not sure how the court remedies that. And I don't see what
the way it gets remedied, Mr. Church, is if you're doing anything that's making the person uncomfortable, that's the complaining witness in this case, the only way for me to take care of that is to put you in jail. Then they don't have to, nobody has to worry. I don't want to do that, but I need you to understand that there's no way around if, you're not contacting them or talking to them. I get that. But if you're doing other things, like sitting in your car and watching them, then that's going to be of concern to me. So I'm ordering you, here's what I'm ordering right now. Listen to what I'm going to say very clearly, okay? This no contact order is going to include literally looking that direction. You can't sit on your front porch. You need to sit in the back. You can't just sit in your car for no good reason. People don't do that. So you're not going to do that. Do you understand? So if they feel uncomfortable, they're going to let Miss Malfino know, and you're going to end up in jail. So I understand you live across the street, but if I were you, I'd walk. If I was going out my front door, get in your car and leave if you're going somewhere. No lingering, no looking that direction, no standing there watching. Otherwise, you're going to end up in jail because I won't have any other choice. Does that make sense? Okay. So we'll reset this for an announcement. Make sure you stay in touch with Mr. Gertz, visit with him before that next court date, and we'll see if we can get an announcement, okay? You're free to go.
Thank you.
Oh, here. One of those is just what I printed out. Do you want the exhibit or does that go in the file? That discussion supports like this. Why don't you work on those other two and I'll call Mr. Stovall in just a few minutes. Miss Grace. Mr. Gregory. Let's see, Mr. Price and Mr. Rennick
Yes, Judge.
on the expunction for Vincent Ponteri.
Right. Yeah.
That expunction shouldn't have been allowed on that, because that was a mistake.
Okay.
It should have been a petition for non-disclosure, and my paralegal filed it.
Oh,
So
okay.
that was our mistake.
All right. So, if you would, I guess, just, file some type of motion to dismiss that when you
Yeah,
file the,
but that was a mistake, and I should have caught it. And I didn't.
okay, perfect. Thank you.
Would we be excused?
Yes, thank you, Mr. Price.
Thank you, Steve.
It's your talk tomorrow.
And are you ready on your sentencing?
Yes.
On Amber Bruno Walker?
Yes, she's present. How are you? Good. Sure.
You see.
Good morning. You are Amber Bruno Walker. And this is cause number 25 DCCR 1814. Ms. Bruno Walker was previously in court, entered a plea of guilty to the state jail felony offense of driving while intoxicated with a child passenger. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor.
The state has, Judge.
Are there any additions or corrections?
None from the defense, Your Honor.
No additions or corrections. However, I do have a comment or a question.
Sure.
And it relates to the defendant's version of page 2. Your Honor, I don't know that it's a full-throated admission of guilt. She refers to this incident as being a distracted driving incident, when in reality it was a rollover crash. She was essentially not cooperative and required a blood search warrant to get her blood.
I made note of that as well.
Judge, I would add to that though is, she did acknowledge in that same thing, although it's not lengthy that they listed, she did also acknowledge in it that this was her responsibility. She said responsible for.
I mean, you tested your blood alcohol by the time they finally got it was 0.0986.
Yes.
I mean, so you definitely were above the legal limit. Are you disputing that?
No.
Okay. So, Ms. Bruno Walker, at this time, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of driving while intoxicated with a child passenger. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but that will be probated on for 5 years. So you'll be on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. So you're going to be regularly tested. The police version is that it rolled over.
It's me there.
It did not roll over. Okay, that's just a. So,
Just so the record's clear, Judge, I've got a photo here. I'll show it to Mr. Rennick as well.
okay. How's that not a rollover?
It's not. It doesn't. It's nothing to get out.
I thought rollover mean like.
Well, it wasn't on all four wheels, was it?
Yeah.
While you had a child in there. So here's part of the important thing about probation is in order to be successful, you've got to completely take responsibility for everything you've done, all of the conditions that you're going to have to do. It gives me some concern that there's some diminishing of that by you right now. So it is very important that you take advantage of everything that you're about to have to do on probation, because if you don't, you're going to be right back in here and you're going to be looking at that 2-year sentence. You understand? So you currently have the auto ignition device on your vehicle?
Yes, I do.
Okay, so you'll make sure and keep that. Obviously, if there's any blows into that are positive for alcohol, it's a violation of your probation. If there's any issue and probation feels like you need anything more than just regular probation, you'll immediately be referred to treatment, whatever that is. It will be ordered by the court. You understand? You can't have a single drink of alcohol while you're on probation. And obviously you can't do anything else, whether it's legal or illegal, without a prescription. If you do everything you're supposed to while you're on this probation, this is a great opportunity because you'll be able to serve that 2-year sentence that you received while you're out on probation instead. But the other side of that is if you violate any condition of probation, you can be brought back into court and you could be your probation revoked and facing that 2-year sentence. You understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rennick. All right, you just need to have a seat here in the courtroom. Yes, ma'am.
Occupational.
Talk to your attorney about that. That's filed somewhere else separately from this. And so have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, ma'am. Thank you.
Judge. Thanks.
They're all like, not me. It's Monday morning. I'm sleepy too. Which one is it? Which one is it? Do you know his name? Sleepyhead, who?
Oh.
John Gray?
John Gray.
John Gray? John Gray?
John Gray. John Gray.
Good morning. You all right, Mr. Gray?
I can't have a thought.
You okay this morning? Why are you sleeping?
Work.
Work. Have a seat in the jury box. I'm gonna get you tested this morning to see if there's anything in your system.
Next thing about that.
Mr. Lewis, you've got Treasurer Harris. It's a sentencing.
Second seat, in the back row. Read it.
Good morning.
Good morning, Jim.
Good morning, ma'am. You are Treasurer Harris. And this is cause number 24, DCCR 1482. And Ms. Harris was previously in court, entered a plea of guilty to unlawful carrying a weapon in prohibited place. I've received the pre-sentence report. Have you both had an opportunity to review that report?
I have, Judge.
I have,
Any additions or corrections?
No, ma'am.
Judge, other than the fact that this court has already admonished her several times about not possessing a weapon and not being on the property of Lamar University, which I think she is no longer involved.
Yeah. Okay. All right, ma'am. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. That includes not possessing a weapon. That includes if someone else has one and they hand it to you, or this situation, you're 2 semesters away from graduating college. You've got to be looking and thinking, how stupid of a decision to make, to not just do it, but let's put it all over social media. It could change your life, and it has, hadn't it? So I want you to be successful. We all do. There's no reason for any of us to think that you're not going to be successful, but it's very important that you follow all of the rules and conditions of probation. So you'll be on that 3-year deferred. If you do everything you're supposed to, this is such a great opportunity because you don't have a felony conviction on your record. Having a felony conviction will change your life in very negative ways. Lots of colleges won't even accept you. And so do everything you're supposed to on the probation. If you do everything you're supposed to, get that community service done up front, pay your fees, do everything correctly, you can even get off probation early. That happens all the time. It's going to be up to you though. So if you don't do everything you're supposed to on this probation, if you violate any condition, you can be brought back into court, found guilty, which means you'll have a felony conviction on your record, and then you can be sentenced anywhere in the range of punishment, which is between 2 years and up to 10 years. So you need to take advantage of this, because I can tell you right now, anything that has to do with guns at this point is obviously being taken extremely seriously in our county. If you're back in here and the underlying offense has something to do with a gun, even though you just held it and did whatever you shouldn't have done with it, you're likely to go to prison for a long time. So nobody wants that. So do everything you're supposed to. It's harder when you're young because your friends are going to be going out and doing certain things that you're not going to be able to do. But these are decisions that are going to affect you long term. So think long term and not short term. Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over your paperwork. All right, good luck to you. Get those last 2 semesters done and graduate, okay? Okay. Davion Mason. Good morning, sir. You're Davion Mason. And will your client waive the formal reading of the indictment?
Yes, ma'am.
Mr. Mason, in cause number 25 DCCR 1511, you're charged with the state jail felony offense of burglary of a building, and that's from August 18th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you made is for a 5-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
Notation.
It's admitted. Is there any evidence that Mr. Mason's not competent?
No.
Is there any issue with restitution?
I have the restitution amount, but I would ask the court, please, just
Go ahead
because
and
of
give
my
me-
prior dealings with Mr. Mason, would you please get a PSI?
Yeah, so
It's
Mr. Mason,
$2,000. There is a co-defendant that I would make
Okay.
it incumbent upon both.
need
of
some more information on that. So, Mr. Mason, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. If there's any restitution, we'll discuss that on that date as well, okay? On your way out of the courtroom today, you need to stop and talk to the probation officer, and she's sitting at that desk right there. All right, we'll see you back at sentencing.
Thank you, Judge.
See, Mr. Lewis, you've got Lance Charbino.
Yes, ma'am.
Do you have his? Oh, that's David Mason's. Never mind, sorry. Good morning, sir. You're Lance Charbino?
Yes, ma'am.
And Mr. Charbino is charged in cause number 25 DCCR 0096 with credit or debit card abuse. And what is the announcement?
Judge, we have a resolution in place, but it's going to require some upfront restitution. So we're asking for some additional time for him to come up with that. About 45 days should be enough. We have to do that.
Something I.
I have no objection to that. Judge, we've offered to reduce it to a misdemeanor based on his having no criminal history. If he'll pay that up front, I believe it's about $5,000.
So here's the thing, Mr. Charbino, I'll do a 45-day reset. Give you some time. If you can get the money together, great. Sounds like that's a great deal. If for some reason you can't, I'm not going to keep resetting it for that. You guys will have to talk about some other resolution.
Yes,
Okay? So do what you can, but I will give you 45 days on that.
Yes, ma'am.
All right. Thank you. You're free to go. Richard Volry, it's a sentencing, Mr. Lewis and Ms. Malfino. Good morning, sir. You're Richard Volry. And Mr. Volry was previously in court and cause number 25 DCCR 1746, entered a plea of guilty to aggravated assault with a deadly weapon, a second-degree felony. And that was, so was it unagreed as to the type of probation, but it was agreed that you would get probation, or just unagreed?
Correct, Your Honor. It was
Okay.
agreed to probation with the court to decide the type and length.
That's what I thought. It was just the way this is worded is a little, okay. And I've received that pre-sentence report. Have you both had an opportunity to review it?
Yeah, Judge.
I have, Your Honor.
Any additions or corrections?
No, not from the defense, Judge.
Judge, other than the court will recall the several times we've been here with respect to the bond issue, this is the one at the Chris Food Mart where we went back and forth on who could be employed there or not.
Yes.
With Mr. Collier, he had called and expressed concern several times. I spoke at length with the author of the PSI, Ms. Ramirez, and let her know my contact with Mr. Collier, and the court would recall that. So that she didn't have to feel like she needed to include all of that. That's why there's a little bit less of a statement from him in the PS. I would ask that the court just take all of those factors into account and his expressed concern as well, and make sure that this individual stays away from him and also away from that location.
So I thought though that it got worked out where he's the one working there, not the other one.
Correct.
Right.
I believe so, but
So the
that-
remain
I guess
away
not-
from the food mart, I'm not
I
gonna
guess
do.
not that, but that he remain away from the antique store that Mr. Collier may own. Is that true?
Yes,
Or
ma'am.
do you own that?
No, ma'am, I'm wearing the device to stay away from there and.
Okay, so do we know the address to that
I
place?
think we had it at the time of the bond.
Yeah,
It's on
included
Magnolia.
It's on Magnolia.
exclusion for that with the GPS.
I have it.
Well, he has an exclusion for the Chris Food Mart because that's where you work.
Yes, ma'am.
And there was some issue at first on who got to work there, and you work there and he does not.
Right.
Okay, but this other place, I don't recall.
32 it was back in March, Judge. We had him trespass warned or admonished not to go to 3235 Pine.
Say it again,
Street,
I'm sorry, 30.
3235 Pine and 3265 Magnolia. And then at that point in time, you had 3090 Gulf, which is the food mart, which obviously
Right.
we will rescind that, I
Okay.
guess.
And these are all in Beaumont.
Correct.
Yes, ma'am.
Okay. Okay, anything else then?
No.
With regard to type of probation, Mr. Lewis?
Well, Judge, I know he has had some limited criminal history there, but we still would ask that the court would consider the further adjudicated probation on him. We think that definitely with his work history, working in the public and things of that nature, I think all of his history has been retail history. So, which of course, if anything does change with his job history, it definitely will make it harder, of course, with a conviction involved. So we are asking that it be given a further condition.
Ms. Malfino?
Judge, obviously with this history, the state would appreciate a straight probation, but more so I would like a lengthy probation. So I'd defer to what you deem is appropriate, but I would ask that it be lengthy.
So here's the thing, based on the nature of the offense and the fact that a firearm was used and exhibited, I am not inclined to give a deferred probation. I think the conviction gives us a little more control and hopefully protection with regard to the ability to possess a firearm, and that's important to me based on this. And so here's what I'm going to do, Mr. Volry. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence. Wait, I can't do it deferred, can I? On an ag assault? Can't, yep.
No.
Yep, we're just
Yeah.
having that issue.
Yeah.
Well, never mind then. Here's what I'm gonna do. Should have figured that out when we took the plea. That would have resolved some things. All right, so Mr. Volry, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to defer all proceedings and place you on probation for 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. One of those includes, obviously, you cannot possess a firearm at any time, at any place, for any reason. Do you understand? In addition to all of regular and whatever conditions of probation that they think are appropriate, you're also ordered that you cannot be at the location of 3235 Pine Street in Beaumont, Texas, and also 3265 Magnolia Street. Do you understand? And have no contact whatsoever with Byron Collier. So if you are anywhere else and he's there also, then you have to leave. Do you understand? Not just these two places, but anywhere else. I am obviously going to allow you, I think everything's still the same as far as I know with you working at the Chris Food Mart, that's fine. But if anything else comes up that is of concern of where he is, or if you think you're gonna get violated because he's somewhere, then you need to let your attorney know, let your probation officer know. Because here's what just happened. So you have a deferred probation. It wasn't what I intended to do, but I legally I have to, and it also gives me actually a lot more of kind of a hammer to hang over your head if something goes wrong. So here's what that means. Right now, you do not have this felony conviction on your record. If you successfully complete this probation, at the end of it, the case is dismissed. You'll never have this felony conviction. But the other side of that is if you violate any condition of probation, because it's a deferred probation, you can be brought back into court. You could then be found guilty of the offense, and I could send you to prison for anywhere in the range of punishment, which is a minimum 2 years up to 20 years. Do you understand? So I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation's going to call you to her desk when she's ready to go over your paperwork. All right. Good luck to you, sir.
Thank you. Okay.
Mr. Nix, you've got Alexandria De Leon.
Yes, Your Honor.
Man. Good. How are you?
I'm good.
I didn't realize that. That's a big issue on that other one. Good morning. You are Alexandria De Leon. And this is cause number 26 DCCR 0143. Ms. De Leon is charged with assault on a peace officer. And what is the announcement?
Your Honor, we'd like to reset. Ms. De Leon has some contractual obligations. She still needs to meet with my office. We've received everything from the district attorney's office. I've been in contact with the district attorney. I think this is going to be a case that we're able to resolve. We'd like to come back in August if that's possible, Your Honor.
We'll just do a normal reset.
Perfect.
Which is about 30 days, and then we'll see where we are at that point. I know you were just hired last month, so
Yes, ma'am.
I mean, I'll give you some leeway, but let's see where we get in 30 days. Ms. De Leon, make sure you stay in touch with Mr. Nick, visit with him about your case, take care of everything you need to. We'll see where we are at that next court date.
Thank you, Judge.
Right, if you're done. And so Mr. Kimmler was going to Hardin County first, and there was the possibility that he was going to be in trial. He didn't know yet. So would you mind send a message or call her, see if she knows yet if he's actually in trial or if he's going to come here? Ernst is working on his. You're just waiting on him, right?
Yes.
All right, Mr. Gray, you have about 5 minutes. If you don't use the restroom within 5 minutes, then I'm going to consider that your test is positive. So drink up, and by 10:15, I want a drug test done. You've been here before, but you have to speak up where I can hear you.
Executing beneficiary of the trust in hand.
Of the trust of what?
Of the trust in hand, yeah.
Of the trust in hand? Whose hand? What trust?
The execution.
Did you bring a copy of it?
I wasn't able to get to the copy. I do have.
Take the glasses off. I need to see your eyes, please.
These are my prescription glasses.
That's okay. So I'm having a hard time understanding you. You need to speak up and speak clearly so that the record can be clear. You were already here, and I gave you an opportunity to try to go hire a lawyer for your 2 cases. Did you get a lawyer hired?
Able to do it.
Who'd you talk to?
Made a few calls to the guy, Rafe. What's his name? Rafe King?
Mm-hmm.
Wasn't able to get them.
Who else?
That's the lawyer that I chose.
So if you chose him, you should have gotten him. I mean, he has the same, there's somebody that answers his phone every week. I understand. I know how it works. I told you to hire someone or visit with at least 3 lawyers.
Made an attempt.
You made an attempt? Okay. Did you go see Mr. Kimmler? Did you make an appointment?
Able to do that.
Why not?
I'm not in a position to be, to go back and forth in front of a lawyer that's in that state that I'm not from. This is for age.
So here's the thing, Mr. Brown, I told you very specific instructions when you were here before. Remington Boykin, Mr. Gertz. Sorry, pull up that docket again. Good morning, sir. Are you Remington Boykin? And will your client waive the formal reading of the indictment?
Yes, Judge.
Mr. Boykin, in cause number 25 DCCR 0396, you're charged with the state jail felony offense of tampering with a governmental record, and that's from August 12th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Speak up, please.
loud. Yeah, yes. Sorry.
And are you pleading guilty because you actually did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Gertz?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 2-year deferred probation. There would be a fine of $500 and restitution ordered in the amount of $3,125. Is that your understanding?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
We have no objection, Judge.
It's admitted. Is there any evidence that Mr. Boykin's not competent?
None at all, Judge.
What's the position since you have restitution? It's a
Judge,
state
we know the
jail.
restitution amount. I believe he has cases pending in other counties, but I don't think he has any prior convictions. I show no other criminal history pending prior to this, so I don't have a problem going forward today.
Okay.
And we agree to waive, Judge.
Okay, thank you. So at this time, Mr. Boykin, I'm going to waive the pre-sentence report. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years. You're ordered to pay the $500 fine and restitution in the amount of $3,125 and to follow all of the rules and conditions of probation. If you do everything you're supposed to on this probation, this is an excellent opportunity because you don't have a felony conviction on your record. And at the end of the probation period, if you're successful, the case will actually be dismissed. You'll never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to the state jail prison for between 6 months and up to 2 years. Do you understand? And I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. You'll have the discovery certification.
Sign that now, please.
You'll need to have a seat after you sign that. Have a seat here in the courtroom. Probation's in that desk right there behind you, and she'll call you up when she's ready to go over your paperwork. You can go ahead and have a seat, sir.
Thank you, Judge.
Just watch for her to call your name.
Yes, ma'am.
Thank you, Your Honor.
Thank you.
I
Huh?
have the attachments and everything.
I'm impressed.
Like I've done this before.
Somebody.
Not you.
Edgar Castillo, do you have that one as well?
That's an attachment.
You have the attachment, that's the hard part.
Lying down again. You can come around this way for you.
Good morning. Are you Edgar Castillo?
Good morning, yes, ma'am.
And Mr. Gertz, will your client waive the formal reading of the indictment?
He will, Judge.
Mr. Castillo, in clause number 25, DCCR 1052, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle, and that's from March 23rd of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Gertz?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 2-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Castillo is not competent?
No, Judge.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to restate your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back at another date for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. So just stop on your way out, and we'll see you back at sentencing. All right, good to go. Thank you. Blaine Dunnigan. Good morning, sir. Are you Blaine Dunnigan? And will your client waive the formal reading of the indictment?
It will, Judge.
See, Mr. Dunnigan, in clause number 25, DCCR 0566, you're charged with the third-degree felony offense of driving while intoxicated, third or more, and that's from April 9th of 2023. The indictment alleges you were previously convicted of driving while intoxicated November 3rd of 2016, and after that was final, you were convicted July 6th of 2020. And how do you plead to that charge?
Yes.
And are those 2 prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they've charged you
Yes,
with?
ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Gertz?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like that agreement is for a 10-year term in prison, but that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
I have no objection, Judge.
It's admitted. Is there any evidence that Mr. Dunnigan's not competent?
None at all, Judge.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll just give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's at that desk right there.
Yes, ma'am.
All right, we'll see you back at sentencing.
Thank you, ma'am.
What about Felicia Freddy? Just go through the motion.
I mean,
I get pleased today and then reset it for sentencing.
Yeah.
So she's
Good morning. Are you Felicia Freddy? Speak up loud and clear so I can hear you and so the court reporter.
Yes, ma'am.
Please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. You can put your hand down. Will your client waive the formal reading of the motion?
She will, Judge.
Ms. Freddie, in cause number 24, DCCR 1390, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation June 23rd of 2025 for the third-degree felony offense of evading arrest or detention with the use of a vehicle, and that was a 2-year deferred probation. Is that correct?
Yes.
Judge, I think there is an error there. I just realized. I think she was placed on misdemeanor eluding probation, not felony.
I think he may be right, Judge. Let me verify that.
We got to put this down, is my recollection. Judge.
My notes in the file indicates that it was a lesser included fleeing or attempted to elude back on June the 23rd of 2025.
Is that a class A or B?
Eluding is to eluding.
I'm not sure, Judge.
If I had a second, Judge, I could.
Here, I'll look at the
Mr.
end.
Smith says B.
Plea papers. A. Of that motion, second amendment. So would the state like to orally amend the motion to revoke?
Yes, Judge. To reflect what was actually played to the lesser included.
Any objection to that?
I don't mind the court amending that motion, Judge. It's probably not what you asked me. I don't object. How about that?
That's good. Thank you. Okay, so let's go back. It looks like then in that motion to revoke now as amended, that you were placed on probation for the lesser offense of eluding arrest or detention, a class A misdemeanor, and that was a 2-year deferred probation. Is that correct?
Yes.
The motion alleges that you violated your probation. Count 1 alleges that you committed the offense. So 2, it's resisting arrest, search, or transport, and a silent abusive call to 911 on November 25th of 2025. And is that true or not true? Count 2 alleges that you failed to dress appropriately and conduct yourself in a courteous and professional manner, especially when interacting with court officers, staff, probation, or law enforcement officers. Is that true or not true?
True.
All right, so I'm going to enter pleas of not true to counts 1 and 2. We'll get an updated pre-sentence report and we will set this for a hearing. Mr. Coleman, is this something with regard to witnesses that we would need maybe a little more time?
Just a little more.
Then at 11 o'clock, we'll do it on a separate day.
No.
So stop and talk to probation on your way out here of the courtroom. We'll reset this for a sentencing hearing. Anything that you think is important, obviously for me to know, get with Mr. Gertz, and then we'll have that hearing on that date. Okay? All right, you're free to go. Just put it like that other one, make a note that I can find a date for it. Yes. Not an 11 o'clock, an actual day. There's 2 up. There was another one, right? Jace Stovall. I do, yes, ma'am. All right, so are you Jay Stovall?
Yes, Your Honor.
And this is cause number 25 DCCR 1872. Mr. Stovall is charged with violating a protective order. And Mr. Gertz has filed a motion to quash the indictment. I've obviously reviewed that motion. Mr. Coleman has filed a response or a reply to that motion, and we're here today on that. I've done obviously some of my own research as well.
Filed a reply to Mr.
A reply to the reply.
Agent.
Oh, just a second, I didn't see that come through.
It's short. It will take you 2 seconds to review it, I would suspect. Hyperbolically, of course. Not attention.
So 1338 has been repealed.
That's my understanding, Judge.
Yeah,
I think
Judge,
I think the applicable statute is 13A.203.
I think that's correct. If you actually read the language of my original motion, I say that it used to be this, it's now been changed to this, and they mean exactly the same thing. The reason I point that out, Judge, is that the legislature recently revisited venue on this statute and chose not to add where the complainant resides as one of the options. And so that's why I was pointing out what the old statute said and what the new statute says. So
So the new statute is what?
it reads almost identical. It's
13.
13A.203.
Thank you. Okay. Getting there. Just give me a second. I want to look at everything real quick. The indictment in the style is 25072, but it should be 25071, I believe. Well, I mean, that's not, it's violation of a protective order, correct?
it has to be multiple to be a felony. And that's
Well,
what gets us to 7.2, I believe.
7.2 is repeated violation of certain court orders or conditions. 7.1 is violation of a protective order.
Right. I think they may have kind of pled it as hybrid, but they're talking about 0.2.
I would concede and agree that it should be 02, Judge.
Okay, so it says 02. That's correct then. All right. Okay. So with regard then, to the new 13A 203, this is not a protective order,
It is a protective order,
but
Judge.
the indictment alleges violating a condition of a bond.
I will again concede error on the state's part, and that could be remedied, as I put in my reply, simply by amending the indictment.
Well, I think that probably should have been done because I
didn't want to amend it until I got the court's ruling on the other issue, the issue of venue.
but that matters. So, okay, so let's do it this way. If it's a protective order specifically, then 13A 203 appears to be specifically on point. So what's the state's position with regard to that? Because it says specifically what the venue is.
Well, my understanding of 13A.203 is that either it can be prosecuted where the protective order was issued or where the offense, quote unquote, was committed. Certainly, we're not seeking to prosecute it in Travis County where it was issued. The fallback would be where the offense is committed. And since statute is silent in the regard as to whether or not it can be venues proper where the complainant resides, I cited cases that I thought were instructive for the court, Your Honor. In other words, an issue here is the offending communication that was sent, electronic communication allegedly sent by this defendant that violated the protective order. And I think the cases that speak to either obscene or harassing communication that we've cited in my reply, it speaks to venue. In fact, the 14th Court of Houston that cites a Court of Criminal Appeals opinion, it specifically says, with regard to an obscene communication, the venue is proper where the applicant or the victim resides. And as it relates to an obscene telephone communication, that's in the an appellate court out of Austin, 1991, that's cited in my reply. It says, with regard to that telephone communication, that venue is proper where the victim resides as well. So again, in construing 13A.203, I think those instances are they're instructive for the court to interpret that statute in the absence of more specific language that could have been or should have been provided by the legislature. And I'll just end with this, Judge. To rule otherwise would render, in my opinion, an absurd result in that a victim would have to travel to wherever this defendant may have made the offending communication, be it on a laptop somewhere in another part of the state, or maybe even outside of the state, Judge. So I just think that in this day and age of cell phones and mobile digital devices, that it's more appropriate for the venue to reside where the defendant received the communication.
Mr. Gertz?
Judge, multiple things that Mr. Coleman said I think are incorrect. First and foremost, the case that he's citing is from 1993. It is pre-social media. It's almost pre-cell phones. The case that he cites too, if you actually read the facts of the case, the person was found guilty of a variety of different harassing communications.
Let's go to what I've looked up and what I've found, so I tend to agree. I mean, the Article 13A 203 does not say that it's where the defendant is. It says where the offense is committed.
Right.
And so the research to me is around offense being committed, what that means, not where he is, where she is. It doesn't say either of those things. So I don't think there's an automatic argument that it has to be where he is. There is Solis v. State, which is a 2003 case, specifically says venues proper if there's substantial contacts with the prosecuting county that has some relationship either to the defendant, his conduct, his victim, or the fruits of his crime. There's many cases that also say the same thing. There is that this is actually a Torres case. The one that I was reading from is a 2023 case that cites that Solis case from 2003. And so I think the same result that in these types of cases, because of electronic communication, to have to say we don't know for certain and can't know for certain where either of them were when they were on their phone or whatever they were on doing, either sending or receiving. And so I don't think it should be limited. I think it is a jury question.
May I be heard on that though, Judge?
Sure.
The default position, and the code gives you a default position. The default position is if it cannot be readily determined by the facts, then it goes back to the three other options, which are where he was arrested, which was Travis County, where he lives, which is Travis County. I mean, Mr. Coleman used the word gravamen of the gravamen of the venue statute is about him, not about the complainant. And
But
so
if
you
it
see
can't be determined from the facts, I'm not doing, that's a jury question, is to determine the facts. I don't think that me determining that is necessarily, I think that would put me in a position where I would put myself in the position of the jury in something that's not necessarily as clear as some indictments where a quash would be potentially granted.
May then I be heard just on one other issue?
Yes, sir.
Mr. Coleman raised. So he said that would render an absurd result if we followed the venue statute narrowly. I would suggest to you that it actually renders an absurd result if we follow it the way the state is proposing. And here's why. What it would allow any complainant to do is go to a really favorable county where the police like that person and the judge likes that person and whatever, and then open their Facebook and say, oh, man, I read it in Jasper County and everybody likes me in Jasper County. Let's bring him who's never been to Jasper County.
Well, is that
here.
the allegation about the complaining witness in this case? Did she come here and do that?
I think
Is
she
that what the
moved
allegation?
home to her family's house, but he's never lived here. He's not been a resident here.
But she has that tie here. She didn't just show up.
I understand, but he's talking about it rendering an absurd result, and I'm saying it's the exact opposite. The venue statute is about whether he has to be hailed in front of a jury for which he has not made his own sufficient ties. It's not about the complainant's ties.
Except that it is sometimes, specifically,
statute.
no, but the Court of Criminal Appeals has found now several times, Court of Appeals cases and Court of Criminal Appeals cases, that venue is proper in a multitude of places. And so based on that, I think this one is not something that is as black and white as I think you're making it sound, or your perception is. I think that it would create the potential for someone to be able to say, I wasn't there when I said, I mean, everything is, so the movement of everyone with computers and phones, I don't think it should be restricted in this case based on what I know and not what I know about the case, what the indictment alleges with regard to the communications being received by the complaining witness in Jefferson County. And that the case law specifically says that venue could be appropriate in a county where the victim is, where the fruits of the crime were, or where the conduct affected someone in that jurisdiction. So based on that, I'm going to deny the motion to quash. We'll reset the case for an announcement. Go ahead.
I'll get the indictment amended.
Okay.
To reflect protective order versus bond.
That's fine. We won't have any objection to that.
Okay.
Judge, as it should be obvious from all the filings, my client lives in Austin. And so what I'd ask, I don't anticipate there's going to be an offer from Mr. Coleman that my client's going to accept. I don't know if you want to do one announcement and then we can put it on trial docket at that point.
Yeah, I mean, unless y'all have already negotiated and received everything and gotten an offer, I'm just going to do a normal reset, and you can reject any offer at that time if there's a rejection, and then we'll get it set for trial after that.
Okay.
All right.
Thank you, Judge.
Ready to go.
Thanks, Judge.
Judge, what time is the game plan for this afternoon?
1.
Thank you.
Yes, sir. Got all kinds of stuff attached to this, that I don't know. Something for angers, there's something on the church.
I think
We're working on that.
response from his office at the time.
I've sent a message to, Judge Thomas. That's where he's supposed to be, I think, and I haven't heard back either. So let's just.
If it's the money email, okay.
I'll send you an email, hard to get that transcript.
He's,
What started as a routine pretrial hearing quickly turned into a heated legal battle over a question that could determine where an entire criminal case would be tried. The case involved allegations that a defendant violated a protective order through electronic communications. But before anyone could discuss guilt or innocence, the defense challenged something much more fundamental: whether the case had even been filed in the correct county. According to the defense, the law governing venue, the location where a criminal case may be prosecuted, did not clearly support keeping the case in the current court. Defense counsel argued that because the defendant lived elsewhere and the communications may have originated outside the county, the prosecution was attempting to stretch the law beyond what the legislature intended. Prosecutors strongly disagreed. They argued that modern electronic communications create unique legal challenges. In their view, the effects of a message mattered just as much as where it was sent. Prosecutors pointed to case law suggesting that venue can be proper where the victim receives the communication and where the alleged harm occurs. They argued that requiring victims to travel across the state every time a message was sent from another location would create an unfair and impractical result. The debate became increasingly technical as both sides cited statutes, appellate decisions, and legal precedent. The judge carefully reviewed the arguments and acknowledged that the law was not entirely black and white. Instead of focusing solely on where the defendant may have been when the messages were sent, the judge examined whether the county had substantial connections to the alleged offense and its impact on the complaining witness. Then came the ruling. After reviewing the statutes and case law, the judge denied the defense motion to quash the indictment. The court concluded that there were sufficient legal grounds for the case to remain in the current jurisdiction and ruled that questions about the facts surrounding the communications would ultimately be matters for a jury to consider. The judge also allowed prosecutors to correct technical issues in the indictment before the case moved forward. By the end of the hearing, no verdict had been reached and no plea agreement had been announced. But one thing was clear. Before a criminal case can reach a jury, courts often have to decide where justice will be administered in the first place. Case question: should online messages be prosecuted where they are sent or where they are received and allegedly cause harm? Like, comment and subscribe for more real courtroom drama, judge reactions, and legal battles.